accept any dilatory motion or referrals as dictated by Order 77.3, that once a business is accepted under a certificate of urgency, it shall not be counted out or adjourned until the business is completed. I will now invite the Honorable Attorney General and Minister of Justice, the person in charge of the bill, to hand over a copy of the bill to the clerk for the first reading. Honorable Attorney General.
Commission of Inquiry Amendment Bill 2023.
Honorable members, in accordance with Standing Order 65, the first reading of the Commission of Inquiry Amendment Bill 2023 is completed. Therefore, in accordance with Standing Orders 66 and 77, we will proceed to the second reading of the bill forthwith. Clerk, may we proceed?
Second reading, Commission of Inquiry Amendment Bill 2023 by the Honorable Attorney General and Minister for Justice.
Honorable members, pursuant to Standing Orders 67 and 77, I invite the Honorable Attorney General and Minister for Justice to move a motion for the second reading of the bill entitled Commission of Inquiry Amendment Bill 2023. Therefore, it will be seconded and the Assembly would debate on the general merits and principles of the bill as per Standing Orders 67.1. After the debate, we will resolve into the Committee of the Whole Assembly to give detailed consideration to the bill. On that note, honorable members, I now invite the Honorable Attorney General and Minister for Justice to move the motion for the second reading.
Thank you, Honorable Speaker. I rise to move that the bill entitled Commission of Inquiry Amendment Bill 2023 be read the second time. Honorable Speaker, this bill seeks to amend the Commission of Inquiry law to add a new provision to define the meanings of minister and white paper under this Act, and to give power to the President to issue amnesty to persons banned from holding public office, and to provide criterion for persons entitled to apply for amnesty under this legislation. I so move, Honorable Speaker.
Thank you, Honorable Minister. Any seconder, honorable members? Honorable Member for Kantora.
Thank you very much, Honorable Speaker. I rise to second the motion. And in respect, I want to rise on a motion for 3F, a motion for the Assembly to resolve itself in the Committee of the Whole House.
Honorable members, there is a motion on the floor. Any seconder? It's seconded by Lower Flood, yes?
Yes, I rise to second the motion.
Honorable members, the motion on the floor is that we resolve immediately into the Committee of the Whole House and forgo the debate. Those in favor, please say aye. Not in favor, please say no. Do we note the person? The ayes have it. Yeah. You know, these things are all done. Honorable members, following the carrying of the motion, it has been moved and seconded earlier that the bill entitled Commission of Inquiry Amendment Bill 2023 be read a second time. Those in favor, please say aye. Not in favor, please say no. The ayes have it. Clerk, can you read the short title of the bill?
Commission of Inquiry Amendment Bill 2023.
Honorable members, I will now resolve the Assembly into the Committee of the whole Assembly to consider the bill in detail. On that note, the Assembly is now resolved into the committee stage. Honorable members, the Assembly will now go into the Committee of the whole Assembly to consider the Commission of Inquiry Amendment Bill 2023, clause by clause.
Clause 1, short title.
It is proposed that clause 1, short title, stand part of the bill. Those in favor, please say aye. Not in favor, please say no. The ayes have it.
Clause 2, Amendment of the Commission of Inquiry Act 1903.
Honorable members, when a clause is mentioned, and probably either you have written or we are not aware, before I come in, you can call my attention that you have a comment. Feel free to do that. Huh? All right. It is proposed that clause 2, amendment of the Commission of Inquiry Act 1903, stand part of the bill. Those in favor, please say aye. Not in favor, please say no. The ayes have it.
Clause 3, introduction of a new section 1A, interpretation section.
No comments. Honorable, I think you before you start discussing, you put us in the picture, because if we pass, we don't come back.
So, where?
Section clause 3,
Clause 3.
introduction of a new section.
Okay. That is the definition of Commission of Inquiry. Honorable Speaker, where we have that 1A, the interpretation. Commission of Inquiry, we intend to just put a full stop where you have 1997 and delete the rest. So it will read, Commission of Inquiry in quotes means the commission issued under Section 200 of the Constitution of the Republic of the Gambia, 1997.
So delete the rest.
Yeah, we delete the rest. And we are further proposing to improve on the definition of white paper. Okay.
Minister. Definition of white paper, yes.
It's the same approach. We would want to insert a full stop at 1997 and remove the rest. So it will read means the commission issued under section 200 of the Constitution of, refers to written statement of the President issued in the Gazette accompanying the publication of a report of a commission in line with section 203A of the Constitution of the Republic of the Gambia 1997. Yes.
No, back the capital letter. The capitals.
Capital
Republic
R,
of the Gambia.
Oh, yes, okay. Capital R, okay. What is the next?
Go ahead. Member, you can go ahead. How were you convinced? Members, the proposed amendments on clause 3. If you look at your document, 1A, you have Commission of Inquiry. Have you seen it? Commission of Inquiry. Members, have you seen it? Yeah. The definition here means the commission issued under section 200 of the Constitution of the Republic of the Gambia 1997. Full stop. The rest goes out. The rest is out. And you go down to what interpretation for white paper. It says refers to the written statement of the President issued in the Gazette accompanying the publication of a report of a commission in line with section 203A of the Constitution of the Republic of the Gambia 1997. Full stop. And the rest goes out. You've got that. Honorable members, it is proposed that clause 3, introduction of a new section 1A interpretation section, stand part of the bill as amended. Those in favor, please say aye. Not in favor, please say no. The ayes have it.
Clause 4, introduction of new section 19. Okay, the minister proposed.
Okay.
Honorable Speaker, the new clause 19 that is being proposed, after 1AB, the sentence that comes after that, where we have the minister shall within 1 week. I don't know whether everybody's there. All right, so we want to offer a substitute there. The minister shall within 1 week publish the names of such persons in the Gazette by way of order instead of schedule. Yes. No. We were removing
That by, you said,
yeah,
persons in the Gazette by way of order.
full stop.
And they add it to these things will all go out.
No. Yes. So we will stop at Gazette by way of order. After Gazette by way of order.
Yeah, this is what I'm saying.
Yes,
After,
exactly.
after Gazette by way of order and the rest goes out.
Yes, the rest goes out. Yeah, so it reads once again, the minister shall within 1 week publish the names of such persons in the Gazette by way of order.
Or, pardon?
No.
No, it's an amendment to an existing one.
It is. We are only adding after Gazette. So read the whole sentence up to you have Gazette.
You add by way of order
By
and
way
remove
of
the
order,
rest.
Capital O. No, by way of order.
No, there is no and. By way of order. After Gazette is by way of order. And then add it to the second schedule, to this act, should all go out.
Yes, exactly. And that very 19, Honorable Speaker, with your permission, the one above, the inquiry there, the E should have been an I.
Inquiry. Commission of Inquiry.
Yes. Inquiry. And
What about, yes?
paragraph 3, finally, on that
Yes, exactly.
place, paragraph 3,
I have,
the eligibility there should be substituted to eligible.
I underlined those one. Be entitled or eligible
Yes.
to emoluments, huh?
Yes. 3, paragraph 3.
Paragraph 3.
A person
person-
removed under this section. You've seen it?
The second line, you will see be entitled or eligibility. Instead of eligibility, it should be eligible to emoluments, pension, gratuity, etc. Any more proposed amendments, Honorable Minister?
No, for this section, no.
No. Any more honorable members on that section? It is proposed that clause 4, introduction of a new section 19, stand part of the bill as amended. Those in favor, please say aye. Not in favor, please say no. The ayes have it.
Clause 5, introduction of a new section 20.
Yes. Honorable Minister, I have questions for you on this. Yes. That is the introduction of a new section where you talk about the section 20, amnesty to persons banned from. Yeah, what I observe is you are empowering the president for those who were banned so that the president can look into their case and either pardon or forgive them. And usually when you go to court and you are convicted for murder, you are sentenced. And the president, after the sentence, the president can pardon you. Prerogative of mercy. Huh? You've committed murder or you committed very heinous crime. Now here, what I observe is a person who is serving a ban from holding public office, pursuant to a finding by a commission of inquiry issued under this act, may apply for a commutation of the ban in writing to the minister. And then it's followed by, upon receiving such application, the minister shall present it to the president as soon as possible for consideration. That one should have a time frame. The minister, because others are time framed. Here, the president may, upon consultation with cabinet, commute the whole or part of this thing. Where the president in collaboration with cabinet commutes the whole of the minister may. There is a portion I'm looking at. No, that is on 6.2. What I'm trying to say is on 6.2. That's where I have my problem. Here, my problem is this one should have a time frame.
So we have a proposal to improve on this.
The time frame could be within a week.
I don't know. That would be most convenient because you know there is bureaucracy all along. So you don't. Yes.
But at least you are saying that there must be a time frame.
Yes. No. For number 2, there should be a time frame.
Exactly.
Yeah. This other one, 4A, there is a time frame. So we want a time frame for the honorable minister on 2. Yeah, to know. When the minister receives it, Speaker, the minister should forward it to the president. From the time of receival to the time of forwarding to the president, it should have a time frame.
Now, I want to propose here to delete as soon as that within 1 week to forward it to the president.
No,
Exactly.
It's difficult. Sometimes the minister is away. So if you give him a 1 week,
So, honorable minister, what are you saying?
we
1 month?
at most
We can give 1 month.
Huh?
no minister will travel more than.
Even if you travel, they will commit to you because it's about somebody's life. Okay, so
Speaker, 2 weeks is maximum of 2 weeks. Within 2
Honorable
weeks.
Speaker,
Honorable, I think any judicious minister will do it even in 3 days, if possible. So let's give it that time to allow it because it's a ban. We don't want a situation where it will be failed. 1 month. The 1 month is the upper limit. Remember, it's the upper limit. It does not mean you have to keep it until 1 month. Yeah, within 1 month. Honorable members, address the chair here. Yes?
Sorry, I was addressed. Honorable
Banjul
Speaker.
Central. Huh? Who is speaking? Is it Deputy Speaker?
Yes, sir.
Yes? You have anything?
Yes, what I was saying, I am in line with the majority leader because I was even proposing 1 week. And the notion adduced by other members that the minister may travel, we are not making laws to take into account of a minister or a holder of office, maybe the person may travel. We are not doing that. So 1 week, it's enough, or 2 weeks, but not 1 month. Yeah, 1 week is enough.
Honorable.
1 week.
Honorable, I think we are giving an upper limit. 1 week does not mean, or 2 weeks does not mean you have to wait until 2 weeks.
Exactly, 1 week.
It means you can do it in even the day you receive it, if it is possible. The next
Exactly,
week.
exactly.
But knowing what happens in bureaucracies, I think 1 month is not unreasonable.
Is 1 month, Honorable
Because
Speaker?
where, for instance, a minister, because it's only the minister who can do it. It's only the minister who can do it.
Honorable Speaker.
Chair. Chair.
Yes, I'm hearing.
Chair, I think now we can make an upper limit of 2 weeks. 2 weeks.
You know, my problem is, Honorable Minister, if it is not done within 14 days, you see, I think the spirit should also show.
Honorable Speaker.
Yes.
Now that the other members, is between 1 week and 2 weeks, we can still settle for 2 weeks as the upper limit.
Yes, that, Honorable, we are on the floor now to bring out the merits and demerits. I know 90% of the people are saying that. But we are trying to see how we can convince each other based on the merits or demerits.
That is why, Honorable Chair.
Speaker,
Honorable Chair.
there also might be an instances.
Majority Leader, please. Yeah, Honorable Chair. That is why we are saying based on the issues taking into account of the bureaucracy, but also bureaucracies that should not also be abused. That is why now we want to settle in for 2 weeks instead of the 1 week. But definitely, I think 2 weeks is more than enough for Honorable Minister to react and communicate. So even if he travels, he may not travel because we are not making laws to cater for ministers' travel time. But I think 2 weeks is enough.
But Honorable, we are making laws bearing in mind some of those things to be able to determine.
Yes, that is why, Honorable Speaker, that is why we are giving him 14 days.
My opinion is a minister can travel for 10, 11 days, 12 days without coming here.
I agree he can even travel for 1 month.
No, but where that happens now, you are forcing us to break a law. You are forcing the institution to break in breach of a law.
No, Honorable Speaker, when things are practically impossible.
Honorable members, I think what we can do is, you are all in favor of a 2 weeks and not a month.
Yes.
14 days.
No, I'm now asking honorable members.
2 weeks, yes.
Honorable Deputy, I've heard you. Honorable members, we have had the agreements. It looks like you are in support of the 2 weeks.
Honorable Speaker, can I come in?
Huh?
Chair, can I come?
Who is saying that? Honorable, I don't want us to encourage debating because there is nothing new we are coming. I think we only decide on it. Members, you are in for 2 weeks.
Yes.
Okay, so now, Honorable, we now came into
14 days.
14 days. That the president, how do you frame it?
Within 14 days present.
The minister shall, within 14 days, present it. There are 2 suggestions. The minister shall, within 14 days, present it to the president. Within shall. No, it may not be him. Remember, you are making this law. It
We will also allow the minister to guide us between 1 week, 14 days, and 1 month.
you refused it only. The minister himself said it, but you refused it. So we can continue. You have another thing, Honorable Minister. On
Sub 4, we want to bring in,
yes.
we are rewriting sub 4. So we are proposing.
Sorry, before you go. Number 2 should read, upon receiving such application, the minister shall within 14 days present it to the president for consideration.
Yes.
As soon as possible should be out.
Yes.
Thank you. Yes, can we now?
Yes, so sub 4 will read as follows, as we are proposing. We'll hand it over soon. It says, where the president, in consultation with cabinet, commutes the whole or part of the ban imposed on the person, the minister shall, within 1 week from the date of such decision, publish the decision in the Gazette by way of order instead of schedule.
Instead of schedule.
No, subsequently, the A and B there talks about.
No, we are dealing with A.
No, we are rewriting 4 in general.
Yes, but what you are saying now is the minister shall within 1 week from the date of such decision publish the decision in the Gazette.
So we are now cancelling both A and B. The new reading is now what we are giving.
Oh, A and B should be out.
Yes, we are now giving you the new reading.
Okay, what is the new reading?
That is it. Where the president, in consultation with cabinet, commutes the whole or part of the ban imposed on the person. The minister shall, within 1 week from the date of such decision.
No, Minister, no A.
No,
It
we are still
continues.
going on.
Yeah?
We are still continuing.
Okay,
It's a continuation.
Okay.
Yes.
The minister, yes?
The minister shall, within 1 week from the date of such decision, publish the decision in the Gazette by way of order. Full stop. That is sub 4. We are now inserting new sub 5.
That's sub 4.
So 4 ends there.
Yes.
So we are now having 5.
Yeah, just hold on. Okay, then you are going to have
sub 5 now.
sub 5, and then B goes out.
Both A and B are gone now. So it's only 4. We just extended 4 and eliminated A and B.
Yes, so what is sub 5?
Let me read it
I will
once.
explain to you.
Okay, he will read again. Then 5 now reads,
go ahead.
the minister shall maintain a register of persons banned from holding public office and may from time to time publish the names of the register.
The minister shall?
The minister shall maintain a register, that is capital R, a register of persons banned from holding public office.
Persons banned.
Persons banned from holding public office, and may, comma, and may, comma,
yes,
from time to time, publish the names on the register in the Gazette.
Publish
the names on the register in the Gazette.
In the register. In the register.
Yeah, but record it first, then you can suggest whether you
In
want
the
us-
register.
in the Gazette. So that's the proposal.
In the register, in the Gazette.
No. Names on the register.
In the Gazette.
On the register in the Gazette.
In the Gazette. All right. Honorable members, the proposal being proposed by the Honorable Minister is on introduction of a new section 20. If you look at it, 5. We have dealt with 5.1. There are no alterations on 5.1. Have you seen it? 1, no changes. 2, there is the changes to include the 14 days, within 14 days. Have you seen that? That is 2 reads, upon receiving such application, the minister shall within 14 days present it to the president for consideration. 3 has no amendments. 4 is to be amended this way. 4 will now read, where the president, in consultation with cabinet, commutes the whole or part of the ban imposed on the person, the minister shall within 1 week from the date of such decision publish the decision in the Gazette by way of order. That is 4 now. Have you got it? No more in A and B. The A and B is gone. 4. And then we are introducing a new 5, sub 5. That should read, the minister shall maintain a register of persons banned from holding public office and may from time to time publish the names on the register in the Gazette. Have you got it? These are the proposals. Yes? Jara? Yes, go ahead. Can you?
Sorry. Sub 4. The minister decided to eliminate the A to join the 2 to make it 1 clause. So here, there was a hyphen after the person, if you are too observant. So yes.
I have told you that this one is gone, all of these things are gone out. It's just that it's redrafted. You are looking at it from the perspective of what is there. You see that they look the same, you are connecting them. There should be no more of that. That's why I read it for you. It should read, 4 should read. No hyphen, no full stop until I tell you full stop. Where the president, in consultation with cabinet, commutes the whole or part of the ban imposed on the person. You know, there used to be a semicolon there. No more. Comma, the minister shall within 1 week from the date of such decision publish the decision in the Gazette by way of order. Full stop. All right. So, and the 5, you've got it. So, any more on...
Honorable Chair, yes.
Yes?
4, I want to, the minister to clear this one. Why now, if there's a conflict of interest in the cabinet, now the person who is affected to be banned, there's a minister that doesn't want it to be happen. Why not we put, or make an instance whereby, in conflict of interest, to be excused from this decision making?
Honorable Speaker, with your permission, we also have our cabinet procedure, like you have your standing orders. So those things apply with cabinet procedure. So you cannot legislate to control how cabinet business is conducted. Yes, cabinet regulates its own proceedings. So if there is a conflict of interest, we know how to handle that within cabinet.
Honorable members, it is proposed that clause 5, introduction of a... Somebody is talking.
Deputy Speaker.
Do you want to say something?
No, what I'm saying, because that was not what he told me. He saw my opinion that he has he has a suggestion to make. And you remember for Lower Saluk, and you gave him the floor, he went and, say something else, which is not in line with what he told me.
Honorable Chair, Honorable Chair.
Honorable members, it is proposed that Clause 5, introduction of a new Section 20, stand part of the bill as amended. Those in favor, please say aye. Not in favor, please say no. The ayes have it.
Clause 6, introduction of a new section 21.
Yeah, Clause 6 is the introduction of a new section.
Yes, Chair.
This is where I have my question, Honorable.
And also I have an issue there, Chair.
Yes, please. We will entertain all your issues.
Okay.
Honorable Minister, that's what that explanation before affects this one. You know, where I was talking about an amnesty or a pardon for somebody convicted with heinous crime. Here you talk about a person may make an application under Section 19, giving conditions as to those banned who can make those applications to the president. You are now putting conditions. One, he or she is serving a ban pursuant to a finding by a commission of inquiry established under this act. One, isn't it? That's very clear. Has not had findings made against him or her that involve the commission of gross human rights violations. That's where my answer. I commented here, I said, why, when murderers can be pardoned by a president without condition, why are you putting this condition there? Just for violation. You want to trust the president to look at the merits and to see in consultation with Cabinet what he can do. I mean, that one should be there. There should be no more barriers. You have to do that. You have to do that. That's where my concern is.
Let me try to respond to, Honorable Speaker, your concern. Section 200 commissions, Section 200 of the Constitution, the commissions that are set up there usually are administrative. In fact, usually they don't deal into human rights issues. But as a matter of emphasis, people who have been found wanting for gross human rights violations, they are not granted amnesty. Now, the comparison that you are drawing for people who are convicted of having committed crimes, murder, any kind of crime, it could be a kind of a crime that, of course, every crime is a violation of a human right, because if you take life or you commit rape or whatever. But gross human right violation is a special category of its own. So it is best practice that gross people who are found wanting for having committed gross human right violations don't enjoy amnesty. And the amnesty here is not intended to benefit those ones. The amnesty we're talking about here is commissions of inquiry set up like the Janneh Commission, like the Local Government Commission, Land Commission, commissions of inquiries that are administrative in nature.
Honorable, you are yet to convince me. I have a lot more to ask. Yes, let me give somebody a chance. Yes, who's Jane? Honorable,
check this.
Deputy Speaker, are you the one?
Yes,
Yes.
I'm the one. Chair, I share your concern, because as the Attorney General indicated, gross human rights violations include taking people's life. Clean. That is gross, serious human rights violations. Right to life, right to everything. And then you, under prerogative of mercy, you can be granted amnesty depending on whatever the Committee on Prerogative of Mercy may recommend. And on this piece of legislation we are about to pass, it deals with Commission of Inquiry. And under the conditions, once you apply, Cabinet will sit and look at your case. That not necessarily have to do with either meeting all the requirements, but other conditions also will dictate Cabinet as to what advice or opinion they will give the President for him to arrive at a decision either to accept or not, then for the Minister to communicate. If you commit other crimes that have nothing to do with this commission of inquiry, like as they indicated here, because you might commit a lot of crimes, but gross human rights violations or killing or otherwise, once it is you apply it before the president, the cabinet should be able to advise you. I don't think we need to put this thing to this thing. My opinion is we should expunge them.
Yes, Honorable. In addition, you know why I'm concerned? These are administrative things through the commissions. Huh? After following due process, going through the courts, because those are the legally due process. You go through the court cases, you finish, and a verdict is given that you are found guilty, and you are convicted and sentenced. After all that, you have empowered the president to look at it and then pardon or not to pardon you. Now, this one, after administrative process, now we are now conditioning because if you talk about gross human rights violations, these are terms used by individuals at any time, even for slapping somebody. There is no, it's everywhere used. But there is no human rights violation worse than killing somebody.
More clarification to help you, Honorable Speaker, with your permission.
Please.
Another major difference is
when it's ready, majority will come and then upper sal.
One major difference we need to bear in mind. For pardon, you must go through a criminal trial and get convicted, and you are serving. That is the only time the president can pardon you. Amnesties in this situation is before you are trial. You go through trial. So we don't want a situation where somebody who is found wanting to having committed a gross human rights violation, even before going to court, you are given an amnesty. This is discouraged in international human rights law. So the example you're giving, if the person was prosecuted and convicted and is serving term, the president under the constitution has prerogative of mercy powers to grant it. But this cannot be granted beforehand.
Thing here is
No.
yes. This here, no, we are saying to look at the ban and then say he's pardoning him from the ban.
Yeah,
He can work, but that doesn't exonerate him from being prosecuted if you want to prosecute
Honorable
him.
Speaker, Honorable Chair.
Yeah, let me.
Honorable Chair.
When I listen
Honorable
very
Chair.
keenly,
Honorable, I'll come to you.
When I listen very keenly, looking at the clause, it reads, a person may make an application under section 19 if he or she has not had finding made against him or her that involve the commission of gross human rights violation. Now, the intention here is not to easily pardon people who have caused havoc, who has really caused gross human rights violation meted against human beings, to come in the name of amnesty, to come and have blanket free. And so,
If I can stop you there,
yes,
can you reconcile that with somebody who is already convicted
yes,
can easily have freedom
Yes.
by being pardoned by the president
yes,
for that violation?
yes,
What mistrust is there that makes the president not to put those into consideration?
yes.
To say that this person, no, you don't deserve a pardon. Because
Because
it's not that when you apply, he will grant you a pardon.
the
It
difference
goes
is
through a process and then he grants it.
the difference is there has reached a judgment that has already made him, face the crimes he commit. No, I'm coming.
He has not faced it. Say there is judgment that has confirmed that he has committed crime.
Exactly.
But he has not faced the crime.
There has a, okay, like the judgment that already confirmed that he is conducted or committed a murder, he's committed this thing and he's been sentenced to jail. So it's somewhat, there has been some sort of justice that has been already meted on him or her. But this one, there has not been a court hearing. There has not been any legal proceedings because of the him or her wanted to come and look for amnesty, we are saying you will not be qualified if you have been committed gross human rights violation.
Chair,
You know,
Chair, let me help them.
He is not yet convicted. When
Chair.
he is banned, he is convicted already by a ban. Let me
Chair.
just get, let me just get.
No, you said me
Yes.
first.
No.
After.
Uh-huh.
Yeah, that's what you
Okay.
said.
You
Chair-
and then who?
Yes,
Upper Salum and then somebody,
Chair.
Kansala,
Me-
Fonyi Bintang.
Majority leader, please. Chair, the minister and the majority leader, we are listening to you. You cannot distract the minister, please. No, we are listening to you. Minister, please. The minister and the majority leader, the minister in his explanation indicated that the difference is that once you are serving in prison for prerogative of mercy, you are serving. You went through a court of law, and that's what the majority leader also emphasized. And you are banned. Once you are banned, you are also serving. You are banned from holding office. No, please. You are banned from holding public office following the commission of inquiry. And because of the ban, you are not holding, you could not hold office. You are serving. It's as good as you also committed, no, please. It's as good as you committed a crime and you are convicted, you are in prison. You are serving. Now you are on ban, you are banned. And the law here is saying 3 years, you serve 3 years on your ban before you are qualified for amnesty. The other people are arguing that, like, you are in prison. If you are serving, and for you to qualify to the amnesty, you must have not been convicted during the period. And if you started serving for 2.5 years and you are convicted, you are in prison, you are not qualified because you have not served 3 years. And it will only kick in after coming from prison. So I don't see the reason why after 3 years. Yes, you are only qualified after serving for 3 years. And then once you are convicted and sentenced in prison, you are serving a jail term. Once a commission of inquiry ban you for 10 years, life also, and the government accept it, you started your ban, you are also serving.
Please.
Yes, thank you.
Yeah, are you ready? Honorable Njai? Honorable. Deputy Speaker,
Yes, sir.
are
Chair.
you ready?
Yes, I am done.
Okay. Honorable member for Upper Salum.
Yes, thank you. I think, Honorable Chair, we are making some confusion here. Conviction is done by a court of law. The banning is not done by a court of law, by a commission that has done that. What what this is actually trying to say, when you are banned, there is a process for that ban to be lifted. And the process is that what they're trying to explain here. First, the person that is banned, you go and apply, and the minister will review based on regular ABC, whatever it is. So for me, it's just like the process on which your ban can be removed. And for me, I think that's my understanding.
It's an appeal. Your ban is not for you to for your ban to be lifted because you have not been found wanting. No, that's not the issue. The issue is after you have been banned, you have to wait for that period, and then you can go and appeal for them to be pardoned, to be given, to be unbanned. That is what is here. Just like if you are convicted and you are serving your sentence, and now you are remorseful and there are recommendations, the president can pardon you. What I am saying here, what the problem here, let's be very clear. The problem is, why is the president giving those powers? For a convicted criminal, after a given time, he can sit down and pardon the person. Why is he giving that power? Because it's based on trust. It's based on trust. So what I'm saying is, if somebody is banned by a commission, which is not through a legal process, it's a commission. We can be anything, the person can do that and this thing can do that. Now the person is banned. And we are saying that here the law is saying, even that ban, you will serve, for instance, 2 years or 3 years as the case may be. All right? But you are now also saying that for gross human rights violations. What do you mean by gross human rights violations?
Okay, that one is very serious.
Chair.
No.
Chair.
Let me learn.
Chair.
What I'm saying here is there are worse things than gross human rights violations.
No, it's Chair.
Speaker.
Chair, allow us
Speaker.
to.
Speaker.
No,
Speaker. Speaker.
Chair.
No.
Chair,
give chance to Unity.
You come in,
Please.
you have your position. Let's hear other positions.
Yes,
Pony,
Tabakanja.
Pony, is it Pony? Bintang,
Thank you.
where are you?
Honorable Chair, I am here, Honorable Chair.
Okay, yes.
I am definitely in line with you, looking at the reason why we have given the president such powers is because he's an entrusted individual by the state. And also, beside, if you are giving him other powers and taking away other powers, it does not actually make real sense. But then here, what we are talking about is, the Honorable Minister spoke about the best practice. I have tried to remove this notion from members and other people saying the best practice. Best practice is only best in the situation that prevails, depending on the condition of the country. What prevails, what is best for us may not be best in other parts of the world. And what is best for developed countries may not be best for underdeveloped countries. So this is why my suggestion is let us remove it as soon as possible.
Thank you.
Chair, can I be heard?
Sin.
Chair, can I be heard,
Chair,
Chair?
I've been raising my tag, please.
Chair.
Honorable Chair.
Chair.
Lower Salom.
Chair, can I be heard?
Chair, I've been raising my tag. Thank you. Thank you very much, Honorable Chair. I think we are trying to solve a situation here. Chair, I cannot understand if an individual or group of individuals who has been proven guilty of a particular crime beyond all reasonable doubt by a competent court can be pardoned by the president. And you're saying here that some individuals or an individual who is banned by a commission cannot be pardoned by the president. I cannot read that. Somebody is here who has been accused of a particular crime, taken to a competent court and found guilty of a particular crime and sentenced for a particular period of time or life imprisonment or whatsoever. And the president can forgive that individual. And now you're trying to make a law saying a commission of inquiry is banning certain individuals or an individual, but the president cannot have powers to forgive that individual. That's not correct. I'm not in line with that.
Honorable Chair.
Chair,
Honorable Chair.
Chair.
Honorable Chair.
Chair, can I come in?
Honorable Chair.
Chair, can I come in?
Lower Salom.
I need to make this clarification. Yeah, what I'm saying.
Honorable Chair.
No, you see, I want, let us set the record, let's set the record straight. We are not saying that the president cannot. I'm coming.
You are not saying.
Okay, I am not saying that the president cannot pardon someone banned on the commission of inquiry. What I am trying to make is that we shouldn't be equating a commission of inquiry ban to a court conviction. These are two things different. And secondly, we understand that the president does have the reserve right under the vetting committee to go and see whosoever he wants to pardon. There is a committee that vet. Anybody who passed the examination, he put pardon on you. But this time around, we are looking at it from a broader perspective. You could be banned by a commission of inquiry not to hold public office. But does that brought healing? Does that brought justice compared to the heinous crime you've committed? We are talking about gross human rights violation. These are not ordinary violations. They are serious violations.
Here is somebody convicted in a court of law. In fact, you can point to that person and say that that person is a criminal. he's a murderer. But a person through a commission is not as strong as a court. No, yeah, this is what I'm saying now. Now, so far we have known that. But somebody who has gone through that stronger position and he's been convicted can be pardoned. Now, you are saying that on a similar level, at a lower level, that person cannot be pardoned. Because you are saying
Yes.
that, according to the Honorable Attorney General, is
Serious human rights violations.
that is not justification.
Chair.
And can you
Chair.
define?
Chair.
No.
Chair,
please,
I want to move a
please,
motion.
Please, we are coming.
Chair.
Can you define serious?
Chair.
No, honorable member,
Chair.
honorable, listen, just a while. What is serious human rights violation? What is the definition? Is the definition here? No. Look, you came here, some of these things are defined, and you define them here.
Chair.
Why don't you define that one here?
Chair.
You are going to give me another definition. All the definitions in this bill are defined somewhere. But that notwithstanding, we put it here.
Honorable Chair. Honorable Chair.
Yes, honorable member for Lower South.
Chair, can you
No,
stop?
majority, please. Give chance to others, please.
Please make your submission.
No. But it's not given to you. Yes. Honorable Chair, I think we are guided by the law here. Honorable Minister, the 1997 Constitution, check Schedule 2, the second schedules. Yes, second schedules. That's 10. And please, let be guided. No, what Lulu? A second schedule, sorry. 1997 Constitution. At page 126. Page 126.
Yes, but can you make reference to the schedule and then the number?
Yes, 11. 7 of the commissions.
Schedule.
Yes.
Schedule number 11.
Yes, number 11, yes.
Okay.
Honorable Minister, help us.
Into the second schedule.
Okay, 11, yes.
Okay.
Number 11, saving of commission of
We don't want to answer. No.
Read, my friend.
Can you continue, please?
Yes. Honorable Chair, that's 11. Service of the commissions of inquiry established during the period commencement 22nd July 1994 up to the coming into force of the Constitution. Where okay, one. This one, I mean.
What is the problem? Honorable, what I have observed from the schedule, honorable member, please, what I have observed from the schedule, 11, you are talking about savings of commissions of inquiry established during the period commencing 22nd July 1994 up to the coming into effect of this Constitution. July 1994 to 1997. That period is what is covered by this. And we are not dealing with that period. That's why when you quoted, when we looked at the section, we try to see. But my problem actually, honorable members, especially the honorable majority leader and of course if you look at the two, we are dealing with 6. And you said number 1, if you look at number 1, a person may make an application under section 19. If section 19, if you go back to section 19 that you reference to, if you look at what page is this? It has no page.
No page.
If you look at the first page, number 4, introduction of a new section 19. If you look at it, implementation of ban from holding public office. You look at it, and we look through it. Where a commission of inquiry submits a report to the government, and the government has published a white paper in respect of the report, and has in the white paper A, accepted the recommendation that a person should be banned from holding public office. B, accepted the recommendation that a person should be dismissed or removed from a public office. The minister shall, within 1 week, publish the names of such persons in the Gazette by way of order. And in respect of paragraph 1, B, the president shall act in accordance with section 167 of the Constitution and subject to relevant enactment of the law, declare that person summarily dismissed or removed from the post with effect from the date specified in the notice. This is just like a court order, a court judgment. That's what we are trying to legalize, because it's commission, we are trying to legalize it. Our problem now is, if you look at this proposed amendment, even after all what we are agreeing, look at 2, number 1, 9.2. Look at 6.2 rather. He said a commutation under this section shall not expunge the findings pursuant to which the ban was made. Huh? Yes, and if you look at that, even when you are pardoned by the president for that from the prisons, you are clean. You go clean. But for the commission of inquiry, even if the president bans you, they said your record will be kept in.
No. Chair.
Please, come ahead.
Yes. I think we need to get this thing very clear about the prerogative of mercy.
This is what, about the?
No, I said we need to get this thing very clear. When you are pardoned, there are two things. You can be pardoned and you still continue, that conviction that actually had continues on you. But you can also be pardoned where you are actually clean, everything is clean.
That is determined by who?
Pardon. I mean, by the president.
In fact, this is what I'm saying.
Yes.
This is what I'm saying. But this one, even there, you close it off.
Yeah.
You are saying that even if he is pardoned, whatever he wants it, you're going to carry it along.
Yes, because what's happening here, this is just giving a pre-qualification. This is giving a pre-qualification for you for your ban to be committed or to be reduced. This is a pre-qualification.
What is a pre-qualification?
That is, you apply on provided that you have not committed any similar crime that you were banned for.
Honorable, let's not create more confusion. No. Assuming that the president now looked through your own lens, the way you want it. He has done it now, and he has said, now I'm pardoning you. All right? Through your own lens. You are telling him, yeah, this one, you are pardoning him, but no, he has to carry the brunt on his back. Now, this is what I'm saying. This thing does not go well, my friend.
Yes.
Remember, this is a commission of inquiry. It's not a court.
Yes, Chair, you are right. But I assume this bill came from the executive, and the president would have seen.
No. That is not our rule.
Yeah. No.
Assume we have made a lot of amendments here. The president might have seen it, but we amended it.
Chair.
We amended it. Now, what I'm trying to say here is, to be honest, is to make things straight. There should be no ambiguity in making laws. That's my position. My position is, if somebody can be pardoned by the president for whatever crime it is, after a given time, if somebody who is banned by a commission, and sometimes we even question commission's reports, and people even go to question it. But what we are saying is, if that happens and we want to legalize it, and the person is either banned or dismissed, there could be errors. If we give the president and the cabinet the powers to look at it, why are we saying that you must serve for 3 years? You must not be, how do you call it, gross human rights violations, which is not interpreted. And then even after you have been pardoned with all those people looking at it, you will still carry along with the log of being banned.
Yes.
You, all the recommendations.
Yes, Chair. One more. Chair, one more thing.
Exonerated.
Chair.
And yet, if I am convicted, and I know I have done the crime, and I'm convicted, after some time, if I am pardoned by the president, it can be cleaned off.
Yeah, Chair. I think there's one thing we need to also clear here. If you are banned, from public office, hold on, GB. What I'm saying here is this: if you are banned from public office, you can seek redress from the courts. But if you don't, we will assume that the ban actually is 100% perfect. There is no one that's prevented from going to the courts to seek redress when you are banned from public office. No, nobody. But if you choose not to go, yeah.
And then you are sentenced, you can appeal. If you state accused, that's there. But if you state accused, the president can pardon you. Even if this one also, if you don't choose to go to court and you feel you are wrong, fine. You may be wrong. We are not questioning that. What we are questioning is why under a lower system, a stronger system, the president can intervene and pardon.
Chair, can I comment, Chair?
This is our argument. And even there, after it is done, you are saying that the person must carry the load.
Chair, can you allow?
Just think that probably you may be banned for some few things. Simple things you may be banned. Yes.
But Chair, from 1997 on to date, you are talking about almost 15 good years. A lot actually has happened. A lot of international commitments signed up by the country actually has also changed. We need to take that into consideration.
No, but
a lot actually has changed for the past 15 years.
What has that got to, those changes? What impact does it have on what we are saying now?
The impact could be on human rights.
No, what I'm saying is you are talking about human rights.
Chair.
Gross violations of human rights. Yes, but where is it defined? And if even there, you are entrusting responsibility. If I have done dangerous things, very bad, wicked things, I am confident that for me to be pardoned by the president, together with cabinet, they will look at those things. They will begin to say, no, we cannot pardon this one. Just like if you bring somebody to be pardoned for murders and all these things, you may make your recommendations. When you come to the president, he may say no. So why are we questioning that?
No. So are you actually saying? Let's get this clear. Are you saying that this insertion is not necessary?
It's not necessary.
I'm saying
it's not
that
necessary.
the power to be able to go for a review for you to be unbanned by the president in consultation with the cabinet is good. But the conditions we are putting in to make it difficult are not necessary.
These should be removed. These should be removed.
Can I be heard?
Yeah.
Chair, can you now, my issue is that I'm in agreement with you that simple bans should not be carried after you've been pardoned. You should not carry it along. I'm in agreement with you.
You know where we differ?
Yes.
Where we differ from my perception
Yes.
is that for me, the reasons why this pardoning, all these things are given to somebody.
Yes.
It's based on trust.
Yes.
So my fears are there. But even with those fears, over the people who have been pardoned over the years, look at them. We do very little of those things. But the person also is in his interest to make sure that he does not let wicked, treacherous people, serious human rights violations, kill us. So easily pardon them.
But that's
if we are not giving those conditions for others, why are we making it so difficult?
Yeah.
My point is, can you allow the minister to clarify this thing?
No,
yes,
Chair,
the
before the
minister
minister
will come. I want the
Chair.
The minister will come in.
Chair.
After hearing from all,
Chair.
summarize it.
Chair, before the minister.
Yes, Honorable
Sabasan.
No, Deputy Speaker. Deputy Speaker.
Yes, who is the other person there?
Sabasanja.
No one.
Sabak Sanja.
Yes.
Yes, after Deputy Speaker, Sabak Sanja.
Now, Honorable Chair, you see, to allay the fears of the human rights activists, all of us are proponents of human rights. Once you committed a serious crime, whether a gross violation of human rights or so, you are put before the court. if you are convicted because of violation of human rights, serious or gross violation of human rights, you are in jail. You are not qualified then to apply because you will not be able to serve the 3-year period. So why be lobbying on this? For me, I think, Honorable Chair, this gross violation of human rights, or if you have any other adverse finding of commission of inquiry issued under this act, am I lost? Yeah. If you commit gross human rights violations, you are expected to be put before a court of law. And once you are convicted, you are not qualified to make an application. Why putting it here? Because there are other laws that regulate violations of human rights and criminalize it. And there are officers of states who bear the responsibility of bringing you before a court of law. So for me, I don't see any rationale behind putting this thing there.
Yes, Chair, I was going to say that we have spent a lot of time on this issue. And
you want us to vote?
Yes, so let's vote, and then we expunge this from
my problem usually, I told you, is before I put a thing to vote, I want us to exchange ideas, because we all want the best to come out, so that we'll be able to convince each other. I may be advocating for something. Probably, if I hear some more others from others, it will change my mind. So that's the reason. For me, honorable members, the purpose is there. Number 1A, I am in agreement. I am not in agreement with B. Probably, if you say the ban, you have to serve it for 3 years. Fine. Yes. But and I am also in agreement with E. That is, has not been convicted for an offense during the period of the ban. You know, if you are on the ban, you still go to be criminalized yourself. We will not consider you. Yes?
Chair.
I will now give the honorable minister to.
Chair.
Expunge what?
21B be expunged. 21B be expunged.
And what about the number 2?
Yeah, we'll come to that. Let's agree on this first.
You are saying that A, B, C, D, E, we expunge B. Huh?
B be expunged. Yes.
B and D.
No, this is okay.
Majority Leader, what is your proposal?
B be expunged.
How about D? With all your arguments, how about D?
D, if you keep on repeating the offense again, a repeated offender.
No, here, honorable.
No,
here it says
naturally,
E has been convicted for an offense during the period of the ban. You know, that's E. We said we are innocent. The D has not had any adverse findings made against him or her by a subsequent commission of inquiry issued under this act or any other law. Meaning, after that commission of inquiry, another commission of inquiry has come. If he has not been found wanting and all these things. Now, if you were in that seat, and you know that I'm trying to appeal for these things now, and then another one has come to knock me down, will you look at my application?
Honorable Speaker, this one doesn't make sense.
No.
It doesn't make sense.
Yes.
Let's delete,
Yes,
I think, B and D.
Yes. Chair, I need to be clear here.
Yes,
and yes, thank you very much for giving me the floor again. I think what we are trying to do here, all of us want to be very clear in what we are doing here. And we've made comparison of the prerogative of mercy under Section 82 of the 1997 Constitution. Even the committee itself, the checks and balances here, to avoid political patronage, they put a portion, subsection 2 is saying that the committee must be, let me just read it. There shall be a committee on the exercise of the prerogative of mercy, consisting of the Attorney General and 3 other persons appointed by the President subject to the confirmation of the National Assembly. This is the checks that they actually have on the prerogative of mercy. What we are trying to get here is
about a committee. You are talking about a committee,
yes,
a guideline for the committee.
Yes.
You see, even the committee's recommendation is not for the president to accept.
No, I'm coming.
Now, this is what I'm saying now. That is a different person. It's a different one.
And Chair,
what I'm trying, let me finish. Let me finish.
And Chair.
What I'm trying to say is, what I'm trying to say here is, the committee, if you go further, the president doesn't just go and grant prerogative of mercy like that. The committee is set up in consultation and also approved by the parliament. Then the president may, after consulting the committee, establish subsection 2, that's the committee prerogative of mercy. Then it goes. Here, what we are trying to do here, just to ensure that we have checks and balances in the people that are banned from public office. That's all we are trying to get here. And the way it is right now, it seems if we remove all this, there will not be anything like that. And
honorable.
Yeah.
What we are saying is there is need for a commission's ruling to be looked into if somebody feels satisfied after he has served some time of the banning. All right? What we are saying is things like he or she has served at least 3 years, we have agreed. And we have agreed also has been convicted for an offense during the period of his ban. Has not been convicted. Huh?
Chair.
No,
Chair.
has not been convicted for an offense during the period of his ban.
Chair.
We have agreed. All what we have problems with is
B and D.
B and D.
Yes.
Exactly.
What we are also saying is the president's, our interest, the president's interest, cabinet's interest, they are the heads of government. Their interest is to maintain peace, order, and the rule of law. That's their interest. And if that is their interest, give them this framework, because a lot of things can happen.
Chair.
But you want to rule it down to that level, even putting down the effort, then you may be pushing somebody to go to a court of law, in fact.
D and B.
Unnecessarily.
Chair.
Yes.
Now, now that the majority leader is convinced, let me help my brother from Opasalu, my neighbor, to convince him. He talks about committee. And this one is saying the entire cabinet, the whole cabinet. And in fact, before the whole cabinet sit on this, they may commit it to a committee of the judiciary or bill drafting or finance of the cabinet.
No, let me help you there. This is submitted to the Attorney General, a legal person. And even before cabinet, the legal person will have consulted and done his things, be able to advise he's the principal advisor to the president.
Exactly.
He will have done all that, and yet still it goes to the cabinet where he sits.
Exactly. And when it goes to cabinet also, they have the opportunity to either subcommittee to look at it or the whole cabinet. This is not a committee of the whole cabinet, not a committee of 5 people. There are more than 15 people.
Okay, Chair.
So I think also to allay his fears.
Yes.
If you commit other crimes, it's there. Look at E. Has not been convicted for an offense during the period of the ban. It's very clear.
Yes, Chair. I want to concede. I want to concede on condition. If you can listen, I can go with the status quo. However, you are saying 3 years. No, but that's what he said. No, wait. Didn't you say that C is okay?
Yes.
Yes. We are fine with C. Yes. What I'm saying, why can't we? What I'm trying to say is, if C is okay the way it is, like 3 years, why can't we make it half? Because somebody could be banned for 3 years. No, wait. You have to listen.
Please, allow him to learn. Please.
Yes. Because somebody could be banned for 3 years. And then if you say that at least 3 years, which means, his disadvantage. If somebody is banned for 5 years, and then he has served more than 3 years, it's more than half. So why not we just say half of the term?
If I am banned, more often than not, and I feel the banning is not correct, do you follow me? By a commission, the banning is not correct. I will not wait for this. I will go to the court. I will go to court and try to ensure that it is removed.
Chair. Chair,
Yes.
please to make progress, we are proposing subclause B and D be expunged. Please.
All right, Honorable Minister, now we can give you the floor.
B and D be expunged.
You have heard from a lot of us now.
Well, a lot of comparison was drawn between the powers vested in the president under the prerogative of mercy provisions in the Constitution. But even in the implementation of the prerogative of mercy, I chair the committee that advises the president, and we have got set of guidelines. That is why you will see whenever we release prisoners, there are still prisoners in prison who have been there for long, they are not going out, because there is a criteria. And this particular provision that you are debating is also trying to just set a criteria. So,
calamity to Gambians. So members said, no, let's have our own regulations. What you say, it has to be regulated. We regulated ourselves. So you people also, if you feel otherwise, the powers, those powers, let them regulate themselves as to where to go. Why do we have to put it here?
I can see Honorable Speaker is very passionate about this one.
No, you know why?
No.
You know, I am taking care of two things.
Oh,
I am of the belief that somebody innocently may be suffering from this and does not have the means and the powers to get it redressed.
Yeah.
This can be an avenue for the
So,
person.
as usual, since legislative making is about trade-off,
Yes?
because when we come here, we have no choice, we have to negotiate. One, of course, A, you have no problem with that. He or she is serving, and B has not been had findings made against him or her. That's the problem with the gross human right violation. Yeah, but gross human right violations are not just ordinary human right violations. But yes.
For instance, the powers that we are giving the president and the cabinet,
yes.
if they feel that in they are looking at the prerogative, the banning, they are considering the ban, they can put their own regulations to say if somebody has gross human rights violations that you people yourselves have defined and agreed to, you can look at it there. And then, because it's not forced that anybody who applies
All
to
right.
pardon.
So we will take that. But then
what is the other one? What is your other objection? We have agreed on that too. Because it's only one left.
So
that is.
I see some members complaining against D.
D. Yes, D.
Yeah, but the D is saying, there can be different commission of inquiries at different times. One commission of inquiry have banned you. If you are also found wanting with a different commission of inquiry, in a typical criminal justice system, that means you are a repeated offender.
If you are a repeated offender and I come before you, what do you do? This is what I'm saying.
So
now,
what I can understand,
we gave
Honorable
you
Speaker.
a framework.
Yes, okay.
And then the details of how you operate those things, that will be with you.
Okay.
But for us to put it here and tomorrow somebody else, whatever we put here, for it to come out, we have to come back to Parliament.
Okay.
But if you make your own regulations, you can change it anytime, depending on circumstances. That's why we are saying that it's 1A, C becomes B, and E becomes C, and it's ended. Are you with us, Honorable?
So, okay, Honorable Speaker, then I will concede by, if you will permit us.
Please, go ahead.
I'll propose maybe after you adopted this introduction of this new section 20, we will appeal that, suggest that the minister be given powers to make regulations under the Commission of Inquiry Act. Then the details, the operational details that we are avoiding to legislate here could do it, because the Commission of Inquiry Act as it is now, you see, even minister, we are just defining it now. So that minister can have powers to make regulations to take care of certain guidelines. So I would trade off for that.
You know, honorable, you know,
Chair.
we are
Chair.
Yes.
Chair Sabasanjal.
One by one.
Sabasanjal.
Sabak Sanjal, yes.
You see, Chair, the Honorable Minister knows that we want to expunge all these ones. Now, for him to have those powers back, you see how he wanted. He wants the regulation to be given to him so that he can get them back again. Let him set up, let them, you know, he made mention of the prerogative of mercy committee. And he has made reference that there are some who are still serving for a long period of time. And still now, they could not be released based on prerogative of mercy because they have set up a criteria. How did they come up with setting up that criteria? Let them use the same strategy to set up criteria to also pardon those, to regulate this. But to say we give them regulation powers, they will go and put all these things again.
I think what he is saying is, so far we are talking about them regulating themselves. He's saying that we give them powers to do that. You know, I have reservations myself. You know, I have reservations.
Chair.
In your own way,
Chair.
even without us empowering you, you can regulate yourselves. But we want to avoid.
Honorable, it's standard practice, Honorable Speaker, that
No,
legislation.
there are people who have regulated themselves. Parliament has not told them to regulate. They have their own regulations. They are carrying on.
But
at various ministries, various areas, they have their own regulations.
But
there are instances when Parliament will say the minister may make these things for the better regulation,
Yes.
for the better. This does not deserve that one. This one you can make your own regulation without me empowering you.
Speaker, I don't understand today.
No. But Speaker, we don't want, you know, if they, when they make their own regulations, and the regulations, they can
Honorable
make it.
Chair.
But Chair, what
Speaker,
I'm saying,
no, Speaker,
can the Honourable Minister make regulation more than the Parent Act?
No, Chair.
What I'm saying, can the Honourable Minister make regulation too powerful than the Parent Act?
No. Here, the act is not preventing that.
Exactly.
No, whatever regulations they may.
The regulation will be in line with the Act.
No. What I'm saying is, when you make that regulation,
Yes.
especially a regulation that emanated from the powers given to them by Parliament, it's law.
Yes.
And now they can go and put certain things there, and you cannot do anything about it.
Yes.
So
Yes,
if they
Chair.
put it there on their own, they regulated themselves.
Chair.
It's no longer coming
Yes,
to
Chair.
us.
Chair, I want to say something.
Chair.
Yes, Chair. I think now, you remember, there was a day here when we are doing some of the bills, and I recommended that when we do these regulations, I said needs to be checked by subsidy legislation. And then you were here. You said, if I remember correctly, that we need to trust these ministers. You remember? So today,
No. This one is different. It's a different one.
Allow him to learn. Allow him to learn.
You cannot use that as a reference.
No, honorable member for Councillor.
is I cannot trust.
Councillor,
Yes.
please.
So what I'm saying is,
Honorable,
yes.
don't answer to him. Continue.
Yes, what I'm saying is, on that day, I think you are very, very clear. In fact, you convinced me that sometimes we need to trust them to do this thing. So today also, let's trust him.
No, Chair.
Now you are right. You are right.
No, Chair.
Please.
Chair.
I will respond to him. You are right. In fact, the same principle I am putting forward by saying that let's trust the president and the cabinet for them to carry out. But why I'm refusing this regulation, I have already known the opinion of the Attorney General.
So you are
to empower him to do it, I'm not very confident.
Chair.
So that's why I said
Chair.
they can do it. But that is not emanating from us giving them those powers, because they have a right to regulate themselves.
No, I understand.
That's
I understand.
deficit.
Chair. No, I understand.
Chair.
I understand.
Yes, now for the purpose of.
My principle usually is
Okay.
you know, when people are
Speaker, can I be heard?
responsibility, give it to them until you otherwise
Yes.
say something.
No.
Just like I say, I don't trust you. I just sit down and I say, they are giving you money. Oh, I don't trust him. Because what I believe when you give me that money, what I will do with the money is what you are going to do with it. That's why I don't trust you.
Okay.
No,
But if I know that if you give me the money, I'll be honest. Why would I mistrust you when you are giving the money and I have not known you to be dishonest?
Okay, now, Chair, for purpose of consistency now in our legislation, I appreciate for the fact that you are an advocate of allowing or trusting ministries to do regulation to better manage their institution. So it should be in this same spirit. I'm also appealing, like the Minister of AG be given powers to regulate this particular provision.
Honorable, that is not a matter of that.
Chair.
You have, honorable, there are hundreds and hundreds of regulations that we are not, that never emanated from us. Ministries, departments, institutions have their regulations that we have not empowered them to do that.
Yeah, but you are
They
asking.
can do it.
No, but let's give it now.
Now that we will be obligated, we will now be attached to that legislation as an institution. So we can say tomorrow, oh, this one definitely we are not in support of. We can say that.
No, now what is the qualms of giving them the powers now?
Huh?
What is the qualms of giving him the powers to regulate now?
No, what we are saying is,
Yes.
every institution, whether you are given, whether
No,
you-
under this particular act I'm talking about, at the last page, let's put regulation that the minister should be given.
No.
Why?
We have not done it for any other. Honorable members, we have now finalized on 6-1. We have A is in place, 1 is in place, A is in place. B is out, C is going to be B, D is out, and then E is going to be C. Have you got it? Original B and D are expunged, and then it is renumbered to read A, B, C. Are we in agreement? Anybody not satisfied? Majority, are you satisfied? Majority, are you satisfied?
Yes.
Yes. Honorable member for Upper Salum.
I just want to get clarity.
Yes.
The people that are banned, it's two things. Let's be very clear here. Is it for human rights violations or economic crimes? No, hold on.
Huh?
Yes, I'm just trying to get clarity.
Yeah,
here.
these are, we don't know. It can be for anything. It can be economic crimes. It can be, this is from a commission. It's a commission's report, so it can be probably you slapped somebody, or you took a lot of money, or you embezzled these things, or you had these things. It could be for anything. It's administrative. When that is done, you can be banned. When you are banned for a period, they are saying that you can make an appeal. And that appeal is, the process is what we are looking at. We are saying it's good. If the person deserves to be unbanned, let them unban him. If he doesn't deserve it from their perspective, let them not accept the.
Okay. No, that's fine. So we'll update the CPC then.
Yes.
That's okay.
Yes.
We'll update the CPC.
Honorable members, it is proposed that clause 6, introduction of a new section 21, stand part of the bill as amended. Those in favor, please say aye. Not in favor, please say no. Not in favor, please say no. The ayes have it.
Clause 7, introduction of a new schedule.
I have told you members, I have told members, stop gossiping down. If you want to talk, I don't see you, call my attention. I will give you the floor. There is no need for people to be, it's no need. Yes. No, there is no division. You are going to declare a division.
There's a division.
No, what I'm saying is, you are going to, don't tell me there is division. Say division, and then we can count. We can count.
I call for it.
Yeah, you call for division, but there is no division. Those who said yes, by far outweigh your own. So that's why I said it. But if you call for division, we will count. Okay? Those in favor, your tax up. Those in favor of the amendment. Have you got it? 20. Those against, those who want us to leave it as it is without amendment, raise your tax. Huh? How many? Who are the three? Upper Salu, Banjul South, and Banjul Center. So, those who are abstaining, you are abstaining. One. And Nyanja. Honorable members, the results. Yes? Pardon?
Those who ran away, referring to play.
Honorable members, yes 22, no 3, abstention 2. The yes have it. I am only surprised. I thought that I had convinced the member for Upper Salu, according to what he told me.
Even with your original recommendation.
He went now to say still now he's not convinced.
No. You see, me, I always go with your first recommendation about this regulation. So I really went with that. So that's why I don't want to change. I changed my mind.
Anyway, now we are going to clause
7.
Clause 7 is introduction.
They have a proposal.
Of a new, pardon?
They have a proposal.
A proposal?
To delete it.
To delete?
Minister.
The Honorable Minister has a proposal before I introduce it.
Honorable Speaker, we propose that clause 7 be deleted. We no longer need schedule now, since the Minister will be doing the publication by order in the Gazette.
Honorable members, it is proposed that clause 7, introduction of a new schedule, be deleted. Those in favor, please say aye. Not in favor, please say no. The ayes have it. It's deleted.
Clause 7.
Chair.
And there was a motion, majority.
Yes.
I think, was it who? Who was saying it? You know, we voted yes, no, abstention, and somebody said, and those who ran out.
No. I guess we had a vote on this issue already. Speaker, we are still at the consultation stage. It's not over yet. Any member can also a motion to rescind any decision. We are still on the constitution stage. At this stage,
yeah.
No.
Any member can bring a motion to rescind the decision on any clause. No, it's not late. It's not late.
Yeah, make reference to the relevant standing order.
No, what I'm telling you is not about making reference. But at this stage, you can vote to.
No, we have voted.
I'm not saying we didn't vote. You can vote a clause, but also if you think that you're not convinced again, you can always come back to
who thinks he's not convinced again?
The members.
The members.
Yes.
The members who have voted.
Yes. What was the vote?
No, Speaker, let him bring it. Let him bring a motion.
I wish you were around.
No, Speaker. I think let's put regulation in the bill.
No.
Let's put regulation in the bill.
No, Honorable. They can make their own regulations.
No, what I'm telling you.
Honorable, please let them make their own regulations.
What I'm telling you is for ease of implementing the bill.
But that's what I'm saying. They can make it.
Why can't we give them the power here?
No.
Why?
Why is because we are not making regulations for all the bills that are going to be regulated in the various offices.
Yeah, but then if the minister is asking us as a
there's a purpose why he asked. There was no mention of regulation here.
What purpose?
No,
Speaker. Chair, please.
The assembly now.
No, chair. Chair.
No,
Chair.
Honorable, don't put us in funny position. Honorable members, the assembly now resumes. Honorable members, as per Standing Order 77.3, we will proceed to the third reading of the bill as considered at the consideration stage. I therefore invite the Honorable Minister to report on what had transpired at the consideration stage and move a motion for the third reading accordingly. Honorable Minister. Hey,
Thank you, Honorable Speaker. I rise to report that the bill entitled Commissions of Inquiry Amendment Bill 2023 has gone through the consideration at the Committee of the Whole Assembly with amendments and now be read a third time and passed. Thank you.
Any seconder? Hey, seconder Jibenye. Opanyomi?
Thank you, Honorable Speaker. I rise to second the motion.
Honorable members, I now put the question. It has been reported that the bill entitled Commission of Inquiry Amendment Bill 2023, having gone through the consideration stage at the Committee of the Whole Assembly with amendments, be read a third time and passed. Those in favor, please say aye. Not in favor, please say no. The ayes have it. Clerk, you may read the title of the bill to signify its passing.
Commission of Inquiry Amendment Bill 2023.
Thank you very much. The bill is deemed to have been passed. Honorable members, the Attorney General and Minister for Justice, with his technical team, for ably guiding us through this extraordinary session. We are grateful and we are thankful. Let me thank all of you for your immense contributions to enrich the bills that we looked into through these last 2 days. I thank you all for your time, and I now put the question. Be it resolved that this August Assembly do stand adjourned, sine die. Those in favor, please say aye. Not in favor, please say no. The ayes have it. This Assembly now stands adjourned, sine die.